Sogle amche CCR TV Polinarank, my Mogaco Yokar. Welcome. July 1st, 2024 is an important date for the Indian justice system as 3 new criminal laws have come into effect. The Bharatiya Nyaya Sanhita, BNS in short, in place of Indian Penal Code, IPC, the Bharatiya Nagrik Suraksha Sanhita, BNSS, in place of the Criminal Procedure Code, and the Bharatiya Sakshya Adhinyan, BSA, in place of Indian Evidence Act. While the Home Minister Amit Shah expressed that the new Sanhitas demonstrated the laws framed by Indians for Indians, but some legal experts opined that the new laws will be bringing important changes. They actually don't overhaul the ones already existing. So we have, in short, BNS recognizes new crime, BNSS makes forensic investigation mandatory and digitalizes the legal process, and BSA modernizes the way evidence is handled by welcoming electronic and digital records. They claim that it strengthens transparency in sensitive matters. To throw light on these 3 new laws, we have experts in our own field in Goa, and we have and welcome Advocate Anakleto Viegas from Veli. He is a lawyer practicing criminal law for over 50 years. Anaklet Bab, welcome. We have another constitutional expert, and that's practicing advocate Cleofato Almeida Coutinho. Cleofat Bab, namaskar tuka and moy mogacha yokar. He has been handling constitutional law in law colleges. We have the third member with us, another criminal lawyer, and he is from MAPSA, and he is Raju Poulekar. Baba Raju Bab, namaskar and my mogacha yokar. I think Raju is also known as a great football enthusiast. You were with the Goa Football Association, yes, and you are with Lakshmi Prasad.
Yes.
And we needed to have a lady lawyer and also a criminal lawyer. And she has been also a member, and she is a member of All India Lawyers Union, and dealing with all criminal aspects. And from Margao, Advocate Seola Baz. Welcome, Seola.
Thank you.
We'll open the innings with our senior most lawyer, Anaklet. Could you tell us what your feeling is about these 3 new criminal laws?
It's messy because the law has not changed. Only the name has changed of the law, and 90% of the sections that were there in the other laws have changed their numbers. So we remain where we were, except for a few changes which do not go to the depth of the matter. I will give you a few examples. There are some good points in the law that they have changed, and most of it makes us lawyers students of the law again. Students in the real sense that we have to study that law. We always study, but we study law from the perspective of what the findings are in that law of the higher courts. But here now we have to go to the basics. Not just the lawyers have to go to the basics, the judges have to go to the basics, and the litigant does not know where he stands. If he is charged with murder, he will have to find a section where the section is. If he is charged with rape, he will have to find where the rape section is. So therefore, it's a difficult situation and a messy situation. It doesn't get us anywhere. They say they are expediting the system. It's impossible to expedite it because it has its own flaws, because the infrastructure is not ready to absorb the changes that they have made, technological, digital changes that they have made. It's not possible because in the remote areas, in Goa, of course, we are very comfortable. We have our whole system. We can communicate on internet. We have the WhatsApp messages coming in. We have the documents transferred, the statements of witnesses transferred to us by the courts themselves. If we give our number, the mobile number, the statements of the witnesses come home. this is possible where there is literacy of a very high standard, and all over India that this literacy is not there. Apart from that, in the remote areas there are not even telephones. There are no mobile smartphones to communicate. Therefore, this is an impossibility. It will only drag on the litigation which is now taking about 10 years for a criminal matter and 15 to 20 years for a civil matter, to another 20 years, because the backlog is so big that is not able to this changes will not be able to cope up with the backlog and the new matters that are coming up.
Yeah, you rightly talked about the backlog, and the backlog runs in nearly 5 crores of cases in all the courts all over India. The Supreme Court itself has about nearly 88 or 89,000 cases. So with this backlog, you think that delivery of the justice system will be delayed?
The backlog is so big. That is about 4 to 5 crores in all the courts all over India, and 2 to 3 crores in the high courts. It is not possible, because what would happen is this. Now a new interpretation to this law would be required. New interpretation, new application, because finally you have to interpret the new law as it stands now. That itself will take time, and on that interpretation the matter will have to go from one court to another till the Supreme Court interprets it. That itself will add to the delay, and therefore it will not be simply possible to dispose of matters as expeditiously as they are saying it can happen.
Yes, Advocate, I fully agree with your contention, and you have been a constitutional lawyer.
Yeah.
And they say that old colonial rules, Macaulay was there at that time, but during the independence, the changes have taken place. So what is that remnants of colonialism that they are talking in the legal aspect?
See, the only remnant of colonialism is
Shirt and pant.
the laws were referred to as the Macaulay's Code. And Macaulay's Code was our criminal laws. So somehow it looks like the present Home Minister wanted to don the Macaulay's avatar, so that he would be known in history as someone who changed what Macaulay brought centuries back. Now, second part of colonial era laws. See, colonial era was known for colonial legacy, and if there is any colonial legacy, it is the state's power over the citizens. Now, these laws in fact strengthen the state's power over the citizens, and that makes it more colonial than what the colonial laws were. Now, I remember in the early 80s when I was a student, Anaklet was already an established lawyer, and in many cases and most of the time, Anaklet and his friend Radharao were involved in releasing students who are involved in various agitations. And if we take into account the type of slogans that were given at that time, each one of them would bring them within the sweep of current 152, which is worse than sedition. And that is how the laws have become, at least the present criminal laws are more draconian than what the colonial era laws were.
Yeah, Advocate.
No, one more thing I would also like to add.
Yeah.
See, the criminal law presently and the criminal system has not, or rather these laws have not taken into account who is trapped in this criminal justice system. Who is trapped is the poor and the marginalized in the entire country, and it is these people who will be further trapped in this system.
Yeah.
See, that is the problem of the present laws, because the state makes the system more tighter, more against the poor. Now, another aspect that also has to be pointed out is we are talking of law reforms. For decades now, there have been various committees which have gone into these criminal reforms. One of them is N.R. Madhav Menon Committee, Malimat Committee, and various other committees. But each of these committees suggested section-specific changes. At every section, they suggested changes. But somehow, instead of going for that, they have gone for a whole change, which, as Ananklat said, is a cut and paste job. So if it is a cut and paste job, why change at all? And a reform has to be always progressive. You cannot make a reform retrograde. I say that these criminal laws are retrograde because it makes the police more powerful and it makes the state more powerful.
Yeah, Advocate Cleophas, you talked about sedition, which was there earlier. Now the word sedition is not there, but then they say that it has been brought back through backdoor, and it is much more worse than what.
No, it is worse because it is vague. See, what can be brought within sedition is not known at all. At least under old sedition, there was some sort of a defined concept.
Yeah.
This is a vague concept, and I would say that the present 152 suffers from. See, it will not pass the test of constitutional validity on the concept of its vagueness.
So that means there is.
I would say it is such a vague law cannot be there on the criminal side. It is constitutionally invalid.
Yeah.
The provision is this, 152. It says anyone who raises an objection or points a finger at the sovereignty and integrity of the country would be liable.
For doing what?
For doing what? For speaking
It's
out?
not specified.
No. For speaking out, you're liable.
So, if the way that you spoke as a student in those days, maybe you could be.
Yes, in those
Yes,
days,
yes,
whatever
those
we
days,
spoke
yes.
was definitely within
152 would be have. It could be applicable easily.
Easily.
Because they would like.
So therefore, the power is now with the government to punish for anything they think is.
Absolutely anything could be brought within 152.
Yeah. Advocate Raju Bab, you have been a criminal lawyer for almost 25 years now. You have gone through this new criminal laws. What is your say?
First of all, thank you for having me on your show. See, every act or enactment or law has statement of object in it. There is an object for which it is brought in. Like if you read this BNSS, it says that the object for changing this law was because they felt that there was a lot of backlog of cases and we required speedy justice system, one. Then as far as investigation is concerned, there was much powers for the investigating officers to do the job properly, so more powers were required. Then the compensation scheme and all other aspect. So whether it's BNSS or BNS or BSA, all has object. We need to see whether whatever changes has been brought whether with this acts we can achieve those objects. And BNSS says that the law should be citizen centric. Now, who are citizens? Citizens mean two parties, victim as well as accused. But my take on this, the entire law, it is more of a victim centric than the accused centric. What we require was a balance laws for both victim as well as the accused. And the reason being is this: if you see the criminal cases, entire criminal justice system works on a principle that you are innocent till proven guilty. You are innocent till your full trial. Even if you are inside the jail, you are still considered innocent. And in India, almost 70% cases turns into acquittal. Means what are they? When a case turns into acquittal, he is innocent. Maybe he's got a benefit of doubt in the cases. But at the end, he is innocent. But he has suffered all this time. So therefore, there should all these three laws should be both victim-centric as well as accused-centric, which I find this more tilts on the victim side rather than the accused.
Could it be because there has not been proper consulting period with the experts, maybe with the bar councils and the others?
Yeah, see, if you go back in history of this, the Criminal Procedure Code came, I think so, in 1894. And after 1894, there were various changes in the reforms and changes in the law. And 1973 was the main reform, Even after that, around 20 or 25 amendment was brought by the parliament. Forget about the state amendments brought into the act. But if the act was full-fledged, CRPC or Criminal Procedure Code was full-fledged act or code, then whether we required the full change of this act or we required a certain changes, because if certain changes were required, if like parliament wanted or government wanted to give more powers to police, that could have been given in particular way by amending this provision. But now it is more of chaos because every section has changed. So body remains the same, only you change the clothes from top. But yes, few sections which are good, which is brought in, which we will discuss.
So there are new.
But when he says that 70% of the matters end in acquittal, but still the entire criminal justice system makes the accused suffer.
Yes.
It only means that the entire process itself is the punishment. Nobody is getting punished finally, but the process is the punishment.
Yes.
Now this area should have been dealt with by the reform,
So it's
which has not been touched at all.
Not been rectified at all. So we come to our lady advocate. And,
Before you go to her,
okay,
just a small
yes.
thing. The Indian Penal Code came in 1862.
60.
Yes. And thereafter came the Indian Evidence Act.
70.
Yes. And you can't club them as called colonial because in 1973
Yes.
Yeah.
the Criminal Procedure Code came into being. So how does that become a colonial law?
No, but this is just politics that are being.
Yes, that is what it
There's
is.
nothing more than
There's
that.
nothing more than that.
So
No,
we
but
go-
even the
No, but-
Indian
but-
Penal Code
Yeah.
and Evidence Act were both thereafter
Yes,
ratified by the
rectified,
Parliament.
yes,
They were
ratified.
ratified by the Parliament. They were our laws.
Our laws. They are Indian laws.
It's a misnomer, actually.
India. Interesting fact is none of these laws in the act calls it as a colonial and therefore change. The change of statement of object change is because of particular reasons. Like Evidence Act has been changed to Bharatiya BSA, Bharatiya Sakshya Adhiniyam. In that now they say that what was required was to bring the technology in because we are the emerging society and therefore the technological advancement which is happening. So therefore that kind of evidence should be more made admissible.
Yeah, but,
But yeah, adding to him, the Indian Evidence Act is almost 98% the same, except this part of the
Technology.
Technology.
So there, all that was required was to add maybe additional sections to the old law.
Yes.
There was no need to remove
Yeah.
the existing law at all.
Even the Criminal Procedure Code is the same.
Same,
A
same.
few sections they could have been added at the end,
At the end.
or inserted in
Amendments,
between.
no?
There was no need, and definitely there was no need to call it give a big Sanskrit name. It's an Indian Penal Code.
Yeah.
It's an Indian Evidence Act.
Yes.
And everybody is shouting today because of
No,
we
the
have won that
government-
cricket we have won, and in every nook and corner of India you are hearing only Indian. You don't have any other word. I am an Indian, no.
but today they call it as a Bharat.
Bharat.
Even the
No,
cars
but
that you have
no,
today.
but not the youth who is shouting out India, India. Everywhere you hear that sound.
Yeah. So we talk about the empowerment for women and children. There are some new aspects, beneficiary, that's what they say, for women. And they even have introduced snatching. I think they are knowing that there has been snatching of Mangal Sutras
Yes.
and all that. So that is also reflected now. What is your take on
In any case, when you're going to go and make a complaint about this Mangal Sutra snatching, since it is not an offense which is going to be punishable for with more than 7 years of imprisonment, then the PI, the police officer, has discretion whether he wants to she or he wants to immediately file the FIR or take 14 days of time to have a preliminary investigation and then decide whether this FIR has to be filed. And for this decision, the PI has to refer to the deputy SP. Now the deputy SP is become an integral part of the FIR registering process, and the deputy SP is also somebody who is appointed by the government. So in other words, for crimes which are punishable with less than 7 years imprisonment, government seems to indirectly be involved to understand and to know and to control whether these crimes will be part of the will be part of the data, will be part of investigation, will take the resources of the state for investigation. So this is one of the problems. Any marginalized person, poor, woman, anybody who's marginalized is going to suffer, because even today we suffer. Anytime we go to the police station, all the time we are asked to go back, or they are saying that they are investigating, they are looking into it, and all these things are happening now only. I mean, now only means before 1st of July only. And now after 1st of July, they have this increased power to say no to us. So the citizens are going to be said no to. Secondly, I wanted to reflect on the point that these laws which have come into being, at a time when the parliament had suspended 146 MPs, that is when this law came into the picture. Now, it was 100 MPs from the Lok Sabha and 46 MPs of the Rajya Sabha. Both means it was 18% of the strength of that house. I just happened to calculate now only. 18% of the strength of the house was not there. Not there. And each MP might be representing some 20 lakh people. So you have, again that also I calculated, you have around 3.6 crore people of India who are not part of the passing of the law, not part of the deliberations, not part of the discussions directly. Indirectly everybody is not part of it, but directly so many Indians were not present in the parliament to pass the laws, but they are directly going to be affected by it. Trinamool Congress and Indian National Congress were the two parties. Maximum MPs of theirs only were asked to leave, including then after there was DMK, CPI, NCP and all. So in such a circumstance, it appears to be a top-down approach rather than a bottoms-up approach. Whenever there is some major amendment in any law, especially criminal law, the need and the movement is felt from the bottom. When the Nirbhaya entire episode took place, entire country had a groundswell and there was a need for amendment at that time. That is why the 2013 amendment came. Today there was no such response from the people saying that we want this. There was no such thing. It was only the whim of few people thinking that this is how we want to have the country. So they said, okay, the court has to dispose of these matters within 90 days. Court has to do within 60 days. Police has to do within these many days. Actually, while of course we like expediting and we don't want matters to be pending in the courts, at the same time, we find that the ground was never expecting this kind of a thing, and now the ground only is going to suffer from this kind of a thing. So that is the problem right now with the laws. And as far as pendency of the courts is concerned, it's going to be even worse, just as Dr. has said. Appeals will be there, revisions will be there, because we will ask for revisions saying that that particular application was disposed of under old law, it was not applicable, now it has to be disposed of under this law, and these kind of revisions are
Supreme Court itself has got 80,040 as on July 1, and 25 high courts have more than 61.7 lakh cases. So, Dr. Anaklet, they say that all this is leading to police raj, and even handcuffing, which was not there, has been introduced now. You don't have now the sedition, but you have got terrorism, which is not very well defined. Will this lead to the police, which is already corrupt and we know about it, will give them extra powers now to be extrajudicial?
As pointed out by Siola, you see, the time taken, the time given to the police to arrest and detain the accused has been extended to 3 months' time also, from 15 days. And if the accused remains in custody for more than 15 days, he is liable to be pressurized.
Yes.
Will surrender to whatever the police is saying.
Will this lead to greater corruption? We have seen a lot of cases now in Goa, for example, in Asagaon and in Benauli, Utorda and all that. So, giving extra powers to police, the corruption will definitely go very, very high.
Yes.
It may or may not go, but the whole system is going to be against the accused. The whole system is going to be against the person who is incarcerated. There is no way he can get out of it.
And in fact, the Supreme Court had also recently said that all police stations have to be equipped with CCTVs, because there are a lot of cruelty taking place during detention. And this itself, all this aspect is also not properly taken into account in this new law. There are some SOPs in place now for arrest, there is videography and all, but that aspect of CCTV and better security for accused persons, that is not dealt with at all. Today itself I was reading one case has come where some boy was detained by one police station somewhere in Ponda.
Yeah.
That the SHO, the IO, somebody is suspended now because yes, this morning his body was found in Maina Kurtori police station's jurisdiction, and it is found that there was some laceration on his neck. So these are the things which are taking place, and they might take place more, or at least justice will not be brought to such people because the accused persons are not going to be handled well, and the police are going to be further cruel, it looks like.
Coming back to that question of
Yeah.
handcuffing, I just
Yeah.
want to refer. Now, I don't think so. In Macaulay's time also, handcuffing was there, but it has brought in now. It is back. Means there was challenge for this handcuffing, and Supreme Court had said that no handcuffing at all unless until you take permission from the court. But here the powers are given to the police to handcuff people who has engaged in offences like drug against children, arms and ammunition against nation, and any offence which carries a sentence of 10 years or life. Now, caution which arises here how this handcuffing will be misused, because we had cases in past that there was a misuse of this. So, what was the reason behind bringing this handcuffing? Although in many countries abroad, like handcuffing is allowed, but whether we needed this here, considering that still in India, a statement made to police officer is not admissible. In that kind of cases, whether handcuff, because a person can be handcuffed, because and that particular section does not, I think it's a 43 something in the BNS, does not take up how long. Whether you can be handcuffed in a police station, whether you can be handcuffed only when you are taken from the police station to the court, or whether you can parade from the police station to the court.
Interpretation is pending.
So
Yeah.
yes, this
That is one. She spoke about timelines being given.
Yes.
Now, it is not that anybody is against the timelines. Speedy justice everybody wants.
yes.
And in fact, as far as this law is concerned, the speedy justice part is very welcome. The issue, similarly, the issue of plea bargaining or community service is also welcome.
Yeah.
But plea bargaining and community service, you did not require a change of the law, the change of the whole law. But on this aspect of timelines, you will remember, and Anaklet will remember, there were those famous Rajdev Sharma cases where the Supreme Court gave directions
Yes.
of certain types of cases should be disposed within certain time,
Correct.
or the cases stand disposed on its own, and thereafter they had to withdraw their own cases because it was not working out. See, this will not work out unless there is a institutional backup to do these things. Like you have to give a judgment within say X days, but then that judge may have to have that much time or that many courts. Otherwise, it is not going to be possible. See, it is not that certain good things which are welcome are not welcome. They are welcome, but welcome things also you require a support, and certain things you don't require a change in law of this nature.
Yeah, in fact, Dr. when IBC came into being, that time also there were those for verification 14 days and certain windows were given. And then the NCLT came up and said that these timelines are discretionary and not mandatory. So the courts take their own course as well.
And with the kind of vacancies that are lying in our judiciary, these timelines have no meaning.
And
Each court is
Extensions.
burdened with 3 courts' work.
Yes.
How will you work out those timelines?
But this plea bargaining, which Dr. was talking about actually, is if you see this plea bargaining concept, the plea bargaining concept has not been changed. In earlier CRPC, it was under 265. Exactly same provision is there, except for little change is made, wherein earlier they said that no, for the 1/4 sentence can be given if you plea bargain and say, all right, I'm ready to plead guilty. But now for the first time offenders, it is said that will be less than 1/4. But if they wanted to dispose whatever, let's say, if you see, like for example, whenever a person does not pay loan, like banks come with this scheme,
OTS.
one-time settlement. Now in India, if you say that 5 crores cases are pending, a little change in law here, in this new law, they could have said that, all right, we are kind of by this law giving you an offer, whichever trials are pending below 7 years. If you plead guilty, perhaps we can let you go by some compensation, so that all that pendency from 5 crores will drop down to maybe 1 crore. 4 crore cases will go automatically. And one more additional, which is not in plea bargaining. Because see, why people are afraid to plea bargain? Because you will not get passport, you cannot contest election, you
Job.
cannot travel abroad. So if a small change to say that if you plead guilty and plea bargain, your records will be deleted, and that conviction will not be used for any other purpose in law. That could drop down the pending cases to many extent, and I feel that even today, if this offer is there or this kind of law is there, accused will take that offer. Why accused is reluctant is because that stigma of conviction is there, lot of other restrictions will come. So therefore, a little change in that plea bargaining could, or strengthening that plea bargaining concept in the BNSS would work wonder to dispose the cases.
No, but again,
yeah.
slightly further, taking this a bit further. See, debate or discussion always helps.
Yes, it does.
Like sometime back when the Negotiable Instruments Act, check dishonor cases were made a criminal offence. Now, how much it added to the already existing
Yes.
court system? It has actually clogged the system.
Yes.
Without knowing what they were doing, they made it a criminal offence and has jammed the system like anything. So if they want to do, say, a arrangement like that, then maybe they will have to first set up dedicated courts
Yes.
and then give these matters to that dedicated court and go ahead. But without any institutional backup, you change the law and see what has happened with the check dishonor cases.
Dr. Cleophas, people are very worried about the sedition law, though this word has disappeared. But under section 150 of BNS, they say that the offence has been made more draconian, and they call it as a backdoor entry for political reasons. The law of sedition made by the British has been abolished, but instead a new section has been added for anti-national activities with severe punishment for those who damage the unity and integrity of India. Many felt that it reads the same as the old sedition law, and they say it could be a pretext, Dr. Anaklet, a pretext to violate the rights of all those who dare speak the truth. What do you say?
See,
That is-
according to me, politicians who are in power and in business, they can always use UAPA, PMLA,
That's what the
Yes,
those type of
that's
sections, those type
already
of
there.
sections. But against social activists, political activists who are not involved in financial transactions, 152 can always be used.
Used.
So, now
It is quite a dangerous provision.
Yes.
All of us can be
all of us
Europeans
can be in.
because we are not on the side of the government.
That is one. And,
uh,
they may not have financial transactions to track,
Yes.
to go on PMLA side. So you can be put 152 inside.
So that means we are in danger.
all of us are in danger. Because this entire debate could be seen as attack on the sovereignty of the country. We have brought something
This law,
Great,
this
and then
law that has been brought in is like demonetization. All of a sudden it is brought
yeah,
in.
exactly. See, catastrophe as demonetization.
Yes,
Same.
just brought in without a thought, without deliberation, without discussion, and when the parliament itself was not functioning, like pointed out, so many of them had been suspended. How can you bring in a law of this kind without even referring it to the parliamentary committee? Such a draconian law, and you are turning the whole law into topsy-turvy.
Yeah.
The last sections have come first.
Yes,
And there is no scheme of things there,
they
and you
say-
can't find the scheme.
Dr.
It is
Anand,
so
but
dangerous.
You can now require ready reckoners. Murder, which
Index,
section under the
index.
old law, which section under the new law. You can come
And you'll
there.
have a dual system operating now.
Yes.
The old system and the new system.
Both it will be pretty
It's
tough
a very
for
difficult,
all of
very
you.
difficult situation for all.
Going back to Dotor's, which Dotor said that regarding the PMLA, if you check the new BNSS, they have also brought in something called proceeds of crime. Means if you collect any money by doing any crime, then like any crime which is there under this particular law, then the powers are given to police. Police can move a magistrate saying that, let's say for example, I'm arrested and I have my house, that no, I have committed some offense and the house which he has bought is from the proceeds of the crime. Freeze his asset. And not only that, if court are given power to freeze that asset and pass a order to distribute that asset to the victims. Now imagine this. The
Immediately, that too immediately.
During pendency.
Imagine this in a state of Goa where husband and wife has 50-50 share. What amount of litigation which will increase with these proceeds of crime? Because even if in PMLA is very different. And these powers are given to police. Imagine in PMLA or the prevention of money laundering cases, the powers are with director and deputy director, and there's a full process to be followed. There's a temporary freezing, then that order has to be confirmed by the authorities, and then it will come to special court, all that. But here, the police can come and say, no, this money, this house is built by the proceeds of crime, freeze that house. I may be also thrown out of the
We
house.
criminal lawyers are in danger. We are all the time receiving money from criminals.
Accused.
From the accused, yes.
Advocate Seola, I have a specific question for you. Under the punishment for extramarital affairs, this talks about BNS section 81. And then section 82 also, husband and wife and all those relations which are there. What is your take on this?
Earlier, this adultery was punishable earlier, long back. Then there was an amendment. First there was a Supreme Court judgment, then there was an amendment which said that we will drop that section entirely. It was a Supreme Court judgment which said that the section has to be dropped, and then I think an amendment followed. So that third party interference in a marriage is decriminalized. But of course it remains a ground for divorce and all. Now, I don't know what they are seeking to do with the new sections, but yeah, there is some introduction of some offense of that nature. And so once again we are going, as
Enticing
Enticing married woman.
Enticing a married woman, then that is an offense under the new act.
So again they are treating women as property. Earlier they were treating women as property, therefore it was an offense. So now are you going back to treating women as property? That becomes this is retrograde. This is worse than colonial.
But
This is
one of the most dangerous section which they have bought in this BNS is that 69. There's a lot of discussion going on. Two people staying together, and men, whoever promises women to marry her and does not marry her, then you can be punished for 10 years.
but this is not rape. It is not amounting to rape,
Yeah, it's
but
not,
it is
yes,
punishable.
it's
Yeah.
punishable.
Obviously,
Yeah.
in one arena, you say that live-in relationship are valid. In live-in relationship, both the parties would do everything which is there, or
Yes,
whatever they
husband
do
and
in
wife, they would
marriage.
be seen in
All
society.
the men may promise women that I will also get a moon for you. So imagine that kind of section 69.
So
Even
that-
10 years sentence, by the way.
Yeah,
It's
maximum
not
10
a
years.
7 years sentence. 10 years sentence for that.
So it will only expand police authority and expand their remand.
Yes.
FIR has
No,
to be
that
registered
is-
Even-
with this
even-
without the
they
preliminary
call it-
inquiry.
They call it penalizing intercourse by deceit.
by deceit.
By deceit, by deceit.
Or promise to marry.
Promise to marry.
But it is not called rape.
Yeah, it's not
It's
called
not
rape,
called
but
rape, it is
penalizing
deceit,
intercourse by deceit.
So imagine the although it's said that today the Domestic Violence Act is misused. Imagine this provision, how it will be misused. Imagine a college students, any girl can file against any boy. Like you can be put inside, have a full-fledged trial, and
You can go for plea bargaining.
you will come out after 10 years.
That is the danger. You see, they have defined a child as an 18-year-old child. You see, at the age of 16, you are already grown up. Yesterday, I was appearing in a bail matter, and the boy was about 25 and she was 15 and a half. So the judge, the children's court judge called her And he says, "Bhai, did he force you?" He says, "No." "Why did you go with him?" "I love him." For how many years? 2.5 years she was in love with that fellow. So therefore, putting her age bar of 18 years could get all our college students in trouble. If the boy just says, "No, I am not meeting you again," she goes and files a rape case. Then what do? He is statutory rape at 18 years, below 18 years. It's a statutory rape, means you have gone with a woman who is a child. So therefore, that definition of 18 years extension from 16 to 18 is incorrect. That has to be looked into.
See, all these things have happened because there was no discussion.
No discussion,
on these
no
laws.
discussion.
I was reading, there were some 12 sittings of the standing committee before these laws could be passed. And whereas we might be sitting only once here, but the judges have been sitting for the last 100 and 150 years and interpreting all these laws. But here we had a committee which sat only 12 times to pass these laws.
But they still say that they are prioritizing cases against women and children.
Yeah, in this manner. In this manner.
Yeah. But is it helpful in the long run?
See, the welcome change, according to me, which they have bought in, is like, let's say a woman goes to the police station to file a FIR. Adi kire atale, like, na, tu amche jurisdiction hai na, go to that
Yes.
police station. With that 0 FIR coming
Yes.
in 173, they have to register that, and then you say send that
To the correct police
police station. So
And
this would
women
help
officers have to be
people. This would help people. Then if in other parts with respect to women itself, they said that in the cases of rape and other offences against women, even the medical assistant has to be given free of cost. That is the extended part. The statement has to be recorded at their residence. It has to be recorded only by the woman police officer. So all those provisions which are victim centric are bought in, and which is good enough in cases against offences against women.
And death penalty for a rape of a minor.
Yes.
But one more thing, finally they have changed the law. And when a law is changed, they talk of reforms. At least there should have been some reforms on sentencing as to how you sentence a criminal who is held guilty.
Yes.
Who should be given death sentence, in which
Oh,
cases,
yes, yes.
not in
That
which
is
cases.
missing entirely.
Death sentence is there, but at least some guidelines for the judge who is giving that sentence.
Correct.
Even that is missing.
Yeah. Whom to give 7, whom to give 5.
Yes.
Yeah.
There is absolutely no discussion.
Only,
No
only
discussion on
change-
these points at all.
No, only change which they have bought in this, that once the court hears the argument, the court has to pass the judgment within 45 days.
Yes.
That is the only change with respect to the court. And same way, when a charge has to be explained,
Yes.
or if somebody has to argue before charge, within 60 days he has to file that application, and within next 60 days the court has to decide. But there is a big vacant area or hollowness between the framing of charge and conclusion of trial. Like there is no timeline frame to conclude these trials. So the trials can still go on as it was going on, maybe 5 years, 10 years, but there is no limit.
There is no limit.
But that provision that women cannot be arrested after sunset, that
is retained. I
that
think,
is retained.
Because
Yes.
there is no reflection on whether that is not retained. So it
That,
is
no,
there only, yeah.
that provision was in old CRPC 46, which says that if you want to arrest any women after sunset and sunrise, then you have to take a permission from magistrate.
Magistrate.
And you take permission and then you allow. So that provision is retained as it is.
So it is there.
It is there.
But do you think that women and children will benefit from these changes?
Yeah, I think to an extent they will. They will benefit a little bit because when a woman will go as a complainant, she will have to be received by a woman officer. And also, as Dotor has said, she can go to any police station, so a police station which is closest to her house, and a 0 FIR will be registered. This is for offences against women, pertaining to women, where the imprisonment is prescribed to be more than 7 years. Those, the FIRs will get registered, and the investigation will commence more immediately. So in that sense, I think women will have a slightly better, easier time under this law. It's a very limited thing though. And as we have already reflected on rape by deceit, not using the word rape, but intercourse by deceit. There are 2 sides and there are 3 sides, and there are sometimes families also involved in that.
The man
kind
is
of-
in danger.
Yeah, very much. But at the same time, I've seen also a lot of these college students, they speak to me, and very complex issues on psychology and relationships comes into the picture. A nice way to deal with it would have been some kind of mandatory rehabilitation or mandatory the counseling or something like that could have reduced any kind of burden on the police also to investigate something like this.
Dr. Cleophas, they have limited court adjournments to 2.
That is a joke.
This is a joke
Joke,
because
joke.
in 2002, the CPC was amended to say that there will not be three
Three adjournments.
So I don't think this
That has any.
this make
I
any
think,
sense.
but there's also provision, I think so it was there earlier also, that a trial should be held on day-to-day
On day-to-day
Day-to-day
correct.
basis.
But
In
309,
sessions,
that's
sessions
309.
matter the day-to-day
Practically-
is provided
It
in
is
the law
there, it is
itself.
there.
Yes.
It is there in the statute.
Practically,
Law
it is
itself.
just impossible for any court to have day-to-day basis trial, because if you see there are around at least north side there are around 7 session or additional sessions court together, and on everyday basis you have around 30 cases, morning 15 and afternoon 15. Now if in 15 cases all 15 cases witnesses come, can you finish like a murder case, drug case, prevention of corruption case, PMLA cases? Because one witness goes in a witness box, he takes the entire session.
Yes.
Rest 14 cases get adjourned for another 15 days. So practically, unless and until we have that number of judges, that
Judges.
number of prosecutors,
Or some
that number
commission
of,
is
courts
constituted.
this will definitely become a very difficult object to achieve.
Yeah, but also they
No,
say
but that is what exactly what I was saying.
Yes.
That you have brought in law without taking into account your institutional backup. See, you have to.
The infrastructure is
Yeah,
not there.
infrastructure is not there.
yes.
So you only after having that, then you can make such laws.
Yes, make such laws.
Doctor, they
Expedition.
also talk about registering FIR no longer mandatory for police.
That is
Yes.
the one
Yes.
which we spoke about.
That
That's
is
a very
that-
bad provision.
No,
Yeah.
in fact, it may be, I do not know, it could be constitutionally invalid because in that
Yeah,
case, you
I will
explain
explain.
that.
Basically, the provision which you are talking about is 173.
Yeah.
This 173 is divided into 2 or 3 parts. The first part is that zero FIR. Second part of that 173.
The EFIR.
Yes, EFIR. Now, what it says that anybody can send a message or email to the police officer that has to be registered as a FIR. Then he has to come to the police station after to the police station within the 3 days and has to sign it. Now, issue arises here for this part. Like let's say I just want to harass someone, I put one email, a fake email or fake SMS and tell the police that there is a murder took place at some. There is no signature on that document. Are police going to register that as a FIR? Because murder is a cognizable offence. Or police are going to say, no, I'm not going to register it. Let him come after 3 days or within 3 days, sign it and then I will see. Maybe possible that yes, indeed there is a murder. So whether the investigation will start without a FIR
Under
is the
that-
issue. Because you have to go there, that recover that body, do pancharama and start.
No, under
your
that
investigation.
170
No,
Under
in
that
fact,
173
under
itself,
the new provision, there is something called a preliminary inquiry.
No, that is the
Before-
third part.
Yes, third part.
So
That
what
is
she is
important.
talking about was the third part of that, where offences which is punishable
3 to 7 years.
from 3 to 7 years, and in that cases the device P, when the complaint comes before device P, he has 15 days time to decide whether I should register this offence
Or not.
to register. So what happens in this, like let's say for example, let's take this Asgaon case only. If that had come to device P had 15 days. 15 days is a long time. You can imagine what can happen
Yes.
in those 15 days. You understand? So like police officers will be acting like a mediator now.
Yes.
Yeah,
Like
that's true, that's
they
true.
perhaps
Which
will
they
be
were
able to
already
settle.
doing. They were
So
already doing that.
unofficially these powers are given to them. You are allowed to settle this. You have 15 days. You decide. If you don't decide not to, then you have to tell the magistrate, inform the magistrate why this FIR was not registered. And if it is not registered, then the complainant can go to the magistrate saying that
That
look,
was there
yes, that
otherwise
was like
also.
156.3 which
Yeah.
was there.
I think
Now,
the-
in one,
Which is the
just to
judgment,
reflect on
Lakshmi Kumari, no?
This one, Lalita Kumari.
Lalita
Lalita
Kumari,
Kumari.
which made it a registration FIR compulsory.
Yes, Lalita Kumari, what it says that when the cognizable offence is made
Made
out,
out.
you have no police officer have no choice. You have to register.
Correct.
Start your investigation. So that Lalita Kumari judgment become redundant now
Yes.
in light of 173 of
Yeah.
BNSS.
Yeah.
so that
no,
means
wait,
But
But
that
coming-
means I do not know whether it could be said to be, of course, there could be a constitutional challenge to this provision, but whereby the police gets a discretion in not registering in FIR.
Yes. In Lalita Kumari also this aspect came. Preliminary inquiry should be done. But it was only limited to the marital discord, 498 cases, limited. Not to like this kind of cases where punishment is up to 7. There will be so many offences in this BNS which is carrying a sentence up to 7 years.
Okay, what
No, but-
happens? Okay, one more thing. What happens in a preliminary inquiry? The 41A notice.
That aspect is there. The section has changed, but
But-
otherwise it is kept as it is. Those 41.
No, but 41A, can 41A be issued during the preliminary inquiry?
No, because no FIR, no.
I think
No,
Dr.
but no,
Sola,
but
you
coming
wanted to say
to
something.
coming to what you were saying about somebody sending a fake SMS or a
Yeah.
fake email about some murder. Anyway, there is a proviso under 173. After the first three aspects are dealt with, there is a proviso that in an event where it is felt that immediate action is required, there the police can immediately start their investigation. They can immediately have action. That maybe they want to save somebody or something like that. So in that kind of information, they can take action. Maybe not investigation, but action they can take.
No, but
Proviso is
FIR,
there.
no FIR. Because see, the FIR is the inception of investigation. You cannot start investigation without
Yes.
a FIR.
In fact, even
Otherwise, if that
senior
kind of
ad-
investigation is done prior to FIR, like it was held bad in law. So
In-
therefore,
in-
the
in-
FIR.
in fact,
No,
no.
but if 41A is there,
Yes.
and if a notice is issued to you prior registration,
Yeah.
do you come as a accused or you come as a witness? Now say Arvind Kejriwal had the problem.
Yes.
Was he called as a witness or he called as a accused?
And
You
then
know,
we
in
have
the
call
preliminary inquiry,
call
in the
letter
preliminary-
and we have
you know,
call letter
yeah.
before 41A. Call letters there also before 41A.
FIR has to be registered. There can be
With
no
first
time
information.
gap because it's the first information in time.
Yeah.
You can always change your mind, you can always add, you can subtract, you can be influenced. These things are bound to happen in case it is not registered. The moment it is registered means you are bound by it. Because people always embellish their stories, with different
Yeah,
kind of
because,
they put yes.
Yeah, the justice will be delayed.
Yeah,
In other words.
No,
And
not only delayed.
Asagaon case is a shining example
Yes.
of
Yes.
what can happen if it is delayed
Yeah.
by
Yes.
15 days
Yes.
period.
Yes.
So,
Yes.
yeah,
Imagine.
it's a great
Imagine.
example.
Imagine.
Yes.
because what they say is that if you don't have proper inquiries and FIR registered, that the police could take a bribes
And they can
they
tamper-
become mediators
Yes.
between the accused and the complainant. That's what
Yes,
Dr.
yes,
you
of-
said
yes,
in
yes.
Asagaon
Correct,
case.
It
correct.
will
They
be a
don't become-
panchayat. It will be a panchayat.
They
in the
don't
police
become
station.
mediators, they become conspirators.
So what is your take now for all of you about the infrastructure, especially technological, and they said a forensic. Now, are we prepared? Do we have that much manpower
No
and
man,
trained people?
absolutely not, absolutely not.
We have to do videography of some statements and arrests and all. I don't know whether they are going to spend that much. There are no ACs in the police stations. There are toilets are not there in the police stations properly.
Is there a storage capability of our
Storage
courts?
capability.
No,
That is not there.
with
Because
respect-
rats are eating cocaine.
Yes.
with
So
respect-
many things, so many things that are required to be done, that it will cost
CDs go missing.
So
heavy
the-
burden on the state.
So the process
Heavy
of
burden on the
the
state.
process of digitization and technology is a myth.
No, not you don't
No,
say the
it
myth.
will- it
Partly
will
it is happening in Goa.
It
Yes.
will-
Partly it is happening in, it's taking roots.
It will take time.
Time, it will take
It
time.
will take time. In any case,
Yes.
for these technological advances, you did not require a change in
Amendment,
law.
exactly.
For a long time,
Sorry,
this has been
change.
happening without any change in law.
Yes.
Yes.
What Amit Shah also said, India will have a complete digital criminal
Okay, it's
records
good.
by 2027. So that means up to then.
As far as this issue is concerned, I was reading this book called Turning Points by our late APJ Abdul Kalam. In 2005, like he had suggested that around 9 suggestions were given by him, and one of the suggestion was that everything has to be digitalized. There should be internet courts, then there should be entire record, or the system of the trial should go on this electronic mode.
Dr. Parolekar, I will-
2005,
Yeah.
now we are in 2024, so that has become reality after 20 years. But in Goa, we have systems. We cannot say we do not.
We don't have.
Other parts of India may be very
That's
difficult.
right, that's right.
But Goa is with respect to the court working on e-court or e-filing, our systems are in place, I believe.
Dr. Raju, I will point out to you that even in Goa, 100% digital connectivity is a distant dream.
See, we have just started.
Just
it.
started.
We
We
just
just started.
started.
We
it.
just started.
Okay. And as I said, everything
But
will
it's
have
going
teething
quite
problem.
all right.
And it will work. Advantage. There's a big advantage in it. Today, the police officers don't have to move for investigation because everything can be done through e. They don't have to come to court. Experts don't have to come to court. Accused don't
Yes.
have to come to court because entire trial can be done by
VC.
Yes.
VC.
Yes.
So that is
No, that is provided for,
Yes.
not yet.
Yes.
We're
No,
getting
no,
ready for
It
it.
is come. It is
Yeah,
there.
no, no, no,
Doctor
but
is
we are
saying,
getting
why
ready
we
for
need,
it.
why
But
we
the
need to
problem
change
is
the
these
law?
things were happening
Yeah.
even before these laws came.
Yes.
You did
Yes.
not require these laws for
No, not at all.
implementing the technological advances that we have made.
This law is only there so that the word samhita can be there on our tongues and roll on our tongues.
No, but
Bharat,
now
you say-
what happens? Earlier it was there and we had started it. Okay, but it is by law recognized. We had problems where
But
one
it
of
could
my
be by rules. We could
one
have
of
made
my
rules.
accused was abroad. The court said, no, how can I allow accused to appear from abroad, out of country? Let him come. But now this Sahita provides for it.
No,
So
our
I can
district,
say
our,
High
no,
Court-
our
every
district
High
court
Court
is
could
doing
have
it.
had
Doing it.
rules.
Our
Yeah.
district courts are doing it.
there was no particular law that accused
No,
can do
without
it.
the law they were doing
Practice
it.
notes could have
Yeah,
been
without
there,
a law,
could be issued.
without a
Practice
law is
notes could be
different.
issued.
Now there is a law to do it. That is the advantage.
Well, even today, summons and everything, they say it's electronic.
See, all this are recognized now. It was done, but recognition
No, but
has come
did
by
you-
way of a law.
Did you have to bring in a law?
Did you have correct? This is the thing. Like say, this is service of summons.
Yeah.
How summons are
Yeah.
sent. Do you require a change in the law?
No, then-
you have to require change in some rules.
Yes.
Rules, yes.
Rules.
Yes.
Even practice notes for VCs would be
I agree.
sufficient.
But that's why I said first at the inception only whether we required this
Yeah.
change and whether it's achieving the object or whether the amendment would suffice to the existing laws.
That's what most of the
Most of the-
experts
yes.
talk about adding the amendments, and then it was going very well. And this also could have been done through amendments.
Amendments, yes.
Yes.
So there will be an increase in the workload of the otherwise overwhelmed judiciary. There is no doubt about it.
No doubt about
Yes.
it. In fact, the
100
higher judiciary will be more overwhelmed
yes.
because every now and then small issues will come for further interpretation.
So the new laws raise concerns about arbitrary detention and abuse of power.
Correct.
So I think we have dealt not in minute detail, but I think we have laid
Quite
the ground
minute it went.
for
To discuss the insanity law.
I must thank all of you, the four experts in your own fields,
I'm
especially
just a junior.
especially
I'm just a junior.
Advocate Anaklet Viegas, Advocate Cleofato, Advocate Raju Paulikar, and the only lady, we needed you to balance, and you have done a good job.
Good job, good job.
We have started debate, discussion. We can always continue as cases progress, and then we will have a better understanding of it. Thank you very much for being with us.
Thank
Thank
you,
you,
Jyoti
thank
sir.
you.
Thank you. Thank you.
Thank you. Thank you.
Yeah.